National Signal Bureau Scandal NSB eye Kwabena Adu Boahen abusua ene Kwabena Adu Boahen akopie mu e court na moma yentie nia ekọọso e court na sewi abusua ya bomode ase be kire ya adwen ha era so aye be media giche be se wase ene de kabani twa channel so a bomode ase obo subscribe e de amebo notification bell no so for more podcast updates yentie Adu Boahen abra okopie mu e court.
So National Signal Bureau abusuya court case no Kwabena Adu Boahen one ne lawyer Atta Kyea ene court etna say on that case attorney general chief justice and other judges na say almost sit on oral cases ewo ho na ene Adu Boahen ekokopie mu judges etna say na Adu Boahen ne lawyer ye friend Atta Kyea no wamba mepie mu ewo court then na ama Atta Kyea then the man dwane free court ama want to me amba mepie mu na according to lawyer Atta Kyea no and so and say legal vacation when judges are on legal vacation any kwan say cases be there ekoso enti lawyer Atta Kyea or say de enti a odwane e de free court and as one kwan kopie mu e wo court on here say judges ne lawyers they are on legal vacation enti adenti na yes yet na case no Kwabena Adu Boahen enti fa so e ma judges no Emma Kwabena Adu Boahen 6 days ultimatum say 6 days no so na Kwabena Adu Boahen amfa ne lawyer amba mepie mu ewo court ono ankasa ebeye cross examination ono ankasa ene beka na asem enti no ene Kwabena Adu Boahen aba lawyer Atta Kyea aba be break silence on court na odwane free na wan kono answer na be kono Ghana has open computer papa and a laptop papa na we use abura perosi computers and accessories and obenya laptop papa na we use the location enye irakwan o Kumase Buokrum Estates Eli Frey number na egu ye screen as no na ade ba kwa ede wom this say okra low budget and a high budget obema quality laptop na HSA we use yembonra yensem ye ba ye de aka ebeto amoso.
Kulabudu there with the latest business news. Let's get to our top stories now. 6 days. That's all the time former National Signals Bureau Director has to present counsel in court, and the clock is ticking. Kwabena Adu Boahen and his wife Angela Boating did not have legal representation present at the Accra High Court when their case was called today. The sitting judge warned if by the next hearing on August 17th there was no legal representation for the two accused persons, either of two things will happen. They will represent themselves, meaning at the stage of the trial, the accused persons will have to cross-examine prosecution's witness, or the said witness will be discharged. Now, 6 days to produce their lawyer. Failure to do so will result in them doing the cross-examination themselves. That's the the essence of what I have just told you. I want to bring in now counsel for Kwabena Adu Boahen, because it appears that a lot of this comes on the back of the conversation around the legal vacations. Samuel Atta Kyea is lead defense counsel in this matter, and he's joined me via Zoom. Counsel, good evening to you. The question on all our minds is why you were not in court today. How do you respond to that? Counsel, you have to unmute so we can hear you. Counsel, we cannot hear you. You'd have to unmute so we can hear you. Oh, it seems as though technology won't allow us have that conversation, but we have lead defense counsel in this matter, Samuel Atta Kyea, over Zoom, and the plan is to answer the questions on all of our minds as to why he wasn't in court today to represent Kwabena Adu Boahen. Counsel, I'll try again. How do you respond to that question as to why you were not in court today?
Yes, we are in the legal vacation, madam, and if you pay regard to the history of legal vacations, it is very obvious that they are not intended for substantial cases before the court, like hard-head criminal cases. They are intended that the lawyers will rest, and where there are emergencies, some consequential motions that should have the attention of the judiciary, the vacation judge will sit and listen to the motions. Now it's even become virtual, that you can sit in the comfort of your law firm and move your motion for the judge to determine one way or the other. So we do not understand why, in the name of expedited trials and ambulance trials, some special court should sit to deal with some special cases, probably to achieve some special ends. We don't understand it. And we wouldn't lend our support to what we see as a complete aberration of the known practice of the courts. That during legal vacations, the lawyers rest. And that is why there are mass of murder cases before the court, rape cases,
I see.
Manslaughter cases, stealing. They are all criminal cases.
So, counsel, just so I
and
understand,
the judges who are conducting these cases are resting, and so are the lawyers. So this selective, arrangement at the instance of the CJ leaves much to be desired, and that discretion, we might want to question it.
So just so I understand, you're saying that your absence today is in defiance of the CJ's orders, that certain cases should be heard during the legal vacation, correct?
Certainly, that is what it is.
I see. I have the Deputy Attorney General here who has written that, look, the legal vacation is not for lawyers. The legal vacation is actually judges' vacation and not for you lawyers. And no lawyer should be telling the Chief Justice that they need to rest. And so some cases should not be called when the Chief Justice chooses otherwise. Dr. Justice Sremsai, how do you respond to what you have heard from lead defense counsel on the Adu Boahen case when he says that I wasn't in court today because it's legal vacation and I should be resting?
Thank you very much. The question is not whether counsel is tired or not. If courts were run based on the tiredness of individual lawyers, you can imagine what would happen in a democracy. So whether counsel is tired or not, no one can take that away from him. The issue is whether a court proceeding should continue simply because counsel says he's tired. And that is where we are of the view that the tiredness of counsel or counsel's private circumstances need not determine whether a case will be heard in court or not. Now, secondly, there are situations where lawyers may have genuine reasons why they cannot come to court. And it may even be true that tiredness may be one of such reasons. But the solution to that problem is not to say and sit in your office and say that you will not attend court because of legal vacation. If a counsel has a problem or is tired, what counsel needs to do as far as the professional law practice is concerned is to appear before the judge and make a case for an adjournment based on the circumstances. Then the judge will consider your plea, and judges have always done that, whether in term time or in vacation. Judges always consider counsel's circumstances in adjourning cases. And I can say on authority that I'm in a couple of cases with my good friend who is the defense lawyer here, Lawyer Atta Kyea, where adjournment has been given, where proceedings have been cut short because of his personal circumstances, where he needed to attend meetings, where he needed to attend to family reasons, adjournment has been secured. So to create the impression that it is because he's tired that he doesn't want to come to court would be a wrong way to look at the issue. Now, secondly, counsel, I understand him to be saying that it is only his case or some specific few cases that are scheduled to be heard in the vacation. That is completely false. And you see, that is a deliberate twist of the facts to create an impression that a system has been set up to persecute some particular individuals. The practice of having cases heard during legal vacation is as old as the judiciary itself. It begins from England, and now we practice it in Ghana. It is something that we've always done. And if you follow what conversation is going on, there is evidence that judges from 2011, for instance, Chief Justice Georgina Wood has actually asked Commercial Court to sit throughout the vacation. There are instances where the previous Chief Justice, so it is a normal thing. The impression being created that some persons are targeted is completely false, in the sense that, you see, there are a number of vacation judges. Oral cases are not before only these judges. There are oral cases in other courts. Those courts, the judges in those courts are not appointed as vacation judges. Therefore, those cases are suspended because the judges are not. And in respect of these judges, they do not only do oral cases, they conduct other cases, like he's mentioning. Some of them conduct robbery, rape, and other cases, and those cases too are ongoing.
So that, you know, just to get the point straight, what you are telling us now is that the legal vacation is not being used to hear only high-profile cases.
At all.
So there are regular cases being heard in certain courts, not interlocutory, but substantially.
Precisely.
Okay, right.
Yeah.
And then it takes me back to the defense counsel in the matter of Kwabena Adu Boahen in court. Counsel, you left your client in a bit of a pickle when you decided that you will not go to court today. What we are learning is that you could have gone to court and then put in a plea with the judge that you needed that needed to be accommodated before then leaving the case. Why wasn't that an option for you?
Because I have petitioned the CJ. The decency of engagement is that it's the CJ that gave the warrant to the judge to continue with the case. So the judge should have stayed in hands and to hear what the CJ will say. That's the decency of everything. You see, so the judge cannot say, okay, I've not heard from the CJ, although it's petitioned from the CJ, but I'm giving you next week, come and do your own case. Please, we should stop this kind of, engagements, so that people will turn around and say somebody is showing disrespect to the judge or whatever.
Perhaps
so who gave the warrant? The CJ. The lawyers have petitioned against the warrants issued by the CJ. Shouldn't we say that let's abide the outcome of the determination of our petition to the CJ and the case should continue? So how can a lay person cross-examine a witness, a prosecution witness? It's such a critical case. How is that going to be done? Are you not subverting his right to counsel? And when counsel,
how is that subversion of right to counsel when it's you that did not show up in court?
You see, sometimes I love to scorn when people believe that lawyers do not have the right to challenge what authorities say. I am not running away from the court. There's an aberration I'm fighting. I do not see how some cases are not slated. The Honorable Sramsa was even given an impression that there are cases that they are doing part heads. You should name the cases. Aside these special ones, that the judges are ready to do part head cases. If people have learned cases, and in the wisdom of the rules of court, we should go on legal vacation. What is the superiority of preference? Now let's do these special cases, and the land cases and the murder cases should go to bed until October. That is selective justice that the Constitution frowns upon. It's obvious. What is special about these cases? What is the emergency about these cases? That they can't abide our return from vacation, everybody's refreshed, and we continue. You're giving everybody an impression that, look, these cases are of priority to you. Why should some cases be of priority to the CJ and not others? This two-track system in which some cases are of no consequence but others matter to the CJ undermines totally the rule of law, and we got to challenge it. Not that anybody is running away from the case. I've been very faithful. You talk to the Attorney General in the prosecution of this case. I've never absented myself once. I've never been to the hospital. He will testify. I'm not running away from my favorite area, litigation. So what is the point? But what is the emergency about this? They can't explain.
We'll have Doug look at that. But before we go to him,
I will not violate the traditions of the practice that we are clear that we should rest, but we are giving oxygen to especially arrangement in which some people who have been arraigned before the court, not on interlocutory matters. You rightly said it, but on full trials that are continuing. It's unfortunate.
Let's go back to, Dag, on the matter of urgency of the cases, because besides you making the assertion that this is selective justice, because you do not believe that regular cases are being heard substantively, the AG has said that is not the case. You're also raising the matter of what is the urgency about these particular high-profile cases that need to be heard during the legal vacation. Dag, what's your response to that?
Yeah, thank you very much. It is unfortunate that even after I have informed counsel and assuming that he didn't know that there is no special treatment for these cases, other cases in these vacation courts are being tried and heard, he still goes on to insist that, to say the thing that he has no knowledge of, which is also not true. So clearly, I am convinced that the purpose of these issues, the purpose of doing what counsel has done is not genuine. It is to perhaps just use this to achieve other purposes. For example, one of the things that we learn in law school, okay, as ethical, is that a lawyer, when you are representing a client, should not avoid the courtroom and use other means to delay court processes. But that's what is happening. Look at what the situation is. There is there's a date for hearing. It was determined you were in court when the date was agreed. Now, you have written a petition to the Chief Justice, and your argument is that until you hear from the Chief Justice on your petition, you will not go to court. But is that how it is done? Even we know that even when you apply for stay of proceedings, until it is granted, the case continues. So on what lawful basis would counsel say that he decided not to go to court because he's waiting the decision of the Chief Justice on his petition? The right thing, as far as my understanding of practice is concerned, is to appear before the court. And even when you go to the court, you can still tell the court that, oh, because I have made this application or this petition to the Chief Justice and I have not heard from him, can you indulge me to hear from the Chief Justice? That is what we are taught to be done. But to refuse to come to court and say that because you have taken some other process and you have not had an outcome, so you will not appear before the court, I'm not sure that is what, as the second person who leads the bar, I'm not sure that is what I would recommend as a proper or a good way of representing a client. And I think you are very right when you said that his decision to not attend to court is what is making his clients suffer. And I think that is exactly what it is. If you have anything, and I have always maintained that judges throughout the country are reasonable people. Even in term time, we all go to court and we sometimes ask favors or basically give reasons why cases should be adjourned or should even be truncated because of our personal circumstances. And I can tell you, judges most of the time will accommodate that. Counsel on the other side will accommodate that because we are human. What this case is presenting is to put the decision whether a case should continue in the hands of a lawyer, right, to decide that I will not come because I think that I am not supposed to come, which is not what the situation should be.
I'll have Counsel Atta Kyea respond to that. But while you come on, gentlemen, I just want to say that we have heard from the Chief Justice on this matter. He's upheld his earlier decision to call certain cases during the legal vacation. I want us to take a listen to the Chief Justice, and then Counsel Atta Kyea, you respond to that briefly for me.
Okay.
To write to the Chief Justice to say that the cases should not be adjourned to the vacation. So I am not coming. I have already made arrangements outside, so I'm not coming. You are a lawyer. You have your clients. If your clients decide to give you leave, well, go on leave. But you cannot say that there's a legal vacation and the judge who is actually sitting cannot do your case. No, that's not it. And then adjournments are not at the instance of the Chief Justice. An adjournment is a judicial act. This is something that is so basic that sometimes when people write that I got a letter saying that I should withdraw the directive and also direct that the cases should be heard in the term time. I said, you went to court and the judge decided that she was right.
So I was when and smart a course so our political highway so 6 days ultimatum for a year. Kwabena Adu Boahen on an area enye easy. Kura better must say some of Japan cocoa teas are in some way at the